Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Indian Evidence Act, we were discussing chapter 8, which is Estoppel, covered between section 115 to 117. In my last class, we have already understood the meaning of estoppel as covered under section 115 along with beautiful chart and illustrations as well as case laws. What are we going to do here? Here we are going to cover the remaining two sections, that is section 116 and 117, along with two beautiful charts, two illustrations and two very interesting case laws. I hope that gives sufficient content as far as estoppel of tenant, licensee, acceptor and bailee. With that, I am taking you to the first slide. I will start this session with a simple illustration. Imagine you need a place for living and Mr. A has a building for rent. Now you are contacting Mr. A and asking him to give that place for rent, and he agrees and you both come to an agreement. After a month, A comes to you to collect the monthly rent, and at that particular time, can you deny the ownership of Mr. A of that building? Now that is what precisely discussed under section 116, which discusses about estoppel of tenant and of licensee or person in possession. Let us first read through the legal provision and then get into my simple chart. The provision says, no tenant of immovable property or person claiming through such tenant shall during the continuance of the tenancy be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title of such immovable property, and no person who came upon any immovable property by the license of the person in possession thereof shall be permitted to deny that such person had a title to such possession at the time when such license was given. It looks like a lot of English, but basically this section is very easy, and let us try understand this with the help of my simple and easy chart. This section covers two important category of people, one tenant, the other one licensee. Now tenant means what? The one who is taking a particular place for rent. Licensee means to run something, he is taking something from a licensor. Now here under section 116, a tenant or a licensee is taking an immovable property from a landlord or a licensor. That is the first very important part that we need to understand. The second important aspect that we need to keep in our mind, that anytime a tenant or licensee coming to an agreement with a landlord or licensor, it is a presumption in law that they have already accepted the ownership. Only after accepting the ownership that you are becoming a tenant or licensee to someone. Otherwise you will not. So once you have agreed the ownership, at later stage you cannot challenge the title of such owner, that is landlord or the licensor. That is all covered under section 116. It is very easy, and one another word that is used there in the second line, that is tenant or his representative. Now who is this representative? Imagine tenant has further given it to someone else as subtenant, or if tenant is dead. Now for example, I am living in that particular home for rent and I am dead. Now who becomes my representatives? My family members. Now my family members cannot deny the ownership of that particular person who has given that building for us on rent basis. Now that is what discussed under section 116, where basically we are seeing two important category of people, that is tenant and licensee, who should not deny the ownership of such owner who has given immovable property for the use of their staying or whatever business that they are doing as license. Now that's all about section 116. To know more group, let us go to section 117. Section 117 covers three important category of people, that is estoppel of acceptor of bill of exchange, bailee or licensee. Just like we approached section 116, Here also I would like to give an illustration. Imagine you want to give your car for service. Now you are taking your car and giving it to service in a service station. So you become bailer and the service station person becomes the bailee. After the service, you go back and want to collect the car, but the bailee or the service station guy says that no, I will not give the car back to you because you are not the owner. Can he do so? Now that is what exactly discussed under section 117, and before going to my chart, let us quickly read through the legal provision. It says, no acceptor of a bill of exchange shall be permitted to deny that the drawer had authority to draw such bill or to endorse it, nor shall any bailee or licensee be permitted to deny that his bailer or licensor had, at the time when the bailment or license commenced, authority to make such bailment or grant such license. Now here there are two important explanations. The first one goes this way. The acceptor of a bill of exchange may deny that the bill was really drawn by the person by whom it purposed to have been drawn, and the second explanation says, if a bailee delivers the goods bailed to a person other than the bailer, he may prove that such person had a right to them as against the bailer. Now that's the provision along with explanation. Now let's get into my chart. As I said earlier, section 117 covers three important category of people, that is an acceptor, a bailee and a licensee. Now the sentence is little cumbersome because when you read them you get confused. So what I have basically done in my chart, I have realigned the entire sentence into an easy frame. It goes this way. It is not permitted to deny the authority of a drawer, bailer, licensor by an acceptor, bailee, licensee respectively at any later stage. It is so easy. Once after accepting a bill of exchange, an acceptor cannot deny the authority of the drawer, or once after accepting the bailment, a bailee cannot deny the authority of the bailer, or once after accepting the license, a licensee cannot deny the authority of the licensor at later stage. That is very important. If you want to deny in the very beginning. Once after you accept the bill of exchange or taking the bailment or taking the license, you cannot do that. That's all about section 117. Saying so, there are two important exceptions in the form of explanation. In the first place, an acceptor has accepted a bill of exchange thinking that a particular person has drawn it, but at later stage if he feels that the same was not drawn by the person purposed to be or intended to be, in that case he can deny that. That is possible. Likewise, a bailee has completed a bailment and he has to deliver it to bailer. Now instead of bailer, someone else has collected it. Like for example, you have given your car for service. Instead of you going, your son goes there and collects it. Now bailee can give your car to your son thinking that he is equivalent to the owner of that car. Now that can be justified by the bailee. Like for example, if it is given by one partner of many partners, now instead of giving to partner A, he can give to partner B. That action can be justified by bailee, which is what mentioned there. To conclude, I have two very interesting case laws in my next slide. Let's go there. While discussing section 115, I have already given three important case laws. However, I thought these two case laws are very interesting and you can remember the facts of these case laws. So I just added them here in this slide. The first one here is Shamim Beg versus Najmunnisa Begum. What happened here? There was a guy who raped another girl. Now, after the rape, she became pregnant. She informed the family members. Now, both the families discussed, and this guy who raped the girl agreed to marry her. In the course of time, she became pregnant, and they prepared a document where he mentioned that he has committed rape, and because of that, she became pregnant, and he will be the legal father of the child which is going to take birth. And he has also agreed to marry her. On the marriage date, she gave birth to a baby. Now, he denied to agree that he is the father of that child, as well as he also denied to marry her. But it was held that now he can't deny the fact that he was not aware that she was pregnant and he is the father of that child. That is what held here. Because in the document itself, he has already mentioned that all of this has happened and he will be the father of the child and he will marry her. When you have agreed for everything earlier, now you cannot change anything. That is what held in this particular case law. The second case law is very interesting, which is Govindji Jeevat versus Sri Saraswati Mills Limited. What happened here? There was an arbitration in progress and a person in the arbitration agreed that he has the liability to make the payment. Now he agreed and accordingly arbitration award was given. But at later stage he tried to challenge the award and it was held that as he has already been agreed in the arbitration process that he has the liability to make the payment, the same will retain. That's what held here. Before getting into my last slide, I just missed to give the right meaning of the term Estoppel, which means to stop. That is the term meaning of Estoppel, and with that I am moving to my conclusion slide. That's all as far as Estoppel is concerned. Before concluding, I just wanted to share one thing. We most of the time think that by spending money, we can keep everything protected. But it's not so. When it comes to relationships, it's not just money which matters. It is the time that we give for that relationship. It is the understanding. It is the amount of conversation that we do. And it is the honesty which takes the relationship long and forever. With that, I am concluding. Thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel. And thanks again.